Welcome to Employment Law This Week. I'm George Whipple. Our top story, a new direction at the NLRB under General Counsel Peter Robb. Robb has issued a memo outlining which cases must be submitted by regional offices to the Division of Advice for guidance. The memo indicates areas in which the new General Counsel will likely ask the board to overturn Obama-era decisions. Robb specifically mentions the joint employer definition that was expanded in browning-ferris, and the purple communications ruling that employees have the right to use their employer's email systems for union activity, among other controversial issues. Don Kruger has more.
The General Counsel's memo clearly signals that there will be a dramatic and for employers welcome change at the board, and that the General Counsel will take an active role in setting the board's agenda. The memo is crucial to understanding the board's priorities going forward, but the proposed changes in case law will take time. The memo rescinds 7 guidance memos and initiatives issued by his Democratic predecessors and outlines priority issues for the General Counsel's review, including Obama board cases issued over the last 8 years that overruled long-standing board precedent and involved one or more dissents, issues that have not yet been decided by the board, or issues that are of interest to the General Counsel.
The Supreme Court has stayed 2 nationwide injunctions on President Trump's travel ban. As a result, the 3rd iteration of the ban is now in effect. The ban restricts travelers from 6 predominantly Muslim countries, along with North Korea and Venezuela, from entering the U.S. Waivers may be granted, and the ban does not apply to green card holders or dual nationals traveling on a passport from a country that is not on the list. This action by the court does not resolve all the legal challenges, but allows the ban to take effect while the 4th and 9th Circuits review the challenges. Both courts heard arguments on the issue last week. Paid leave credits included in the tax bill. As the House and Senate negotiate over tax reform, experts believe that a measure offering tax credits to companies that provide paid family and medical leave is likely to survive. Some critics have noted that the credit would only be in effect for 2 years before it's up for reevaluation. They also question whether it would incentivize more companies to offer paid leave, or just give a tax cut to companies that are already providing the benefit. The final rule on ERISA disability benefits has been delayed. Last year, the DOL released a final rule on claims and appeals for ERISA plans that provide disability benefits. The rule was set to go into effect January 1st, but will now be effective April 1st, 2018. The rule adds safeguards and protections, but stakeholders have argued that it will increase costs. The department will use the extra time to consider these and other comments. And that brings us to our tip of the week. Barbara Harris, Senior Labor and Employment Editor at Thomson Reuters Practical Law, is here with some advice on drafting restrictive covenants and confidentiality agreements.
When drafting restrictive covenants, it's really important not to rely on old forms or precedents. There are many recent developments that have made forms drafted even 1 or 2 years ago already outdated. For example, the Defend Trade Secrets Act, which was passed in 2016, requires employers to include a notice of whistleblower immunity in their non-compete agreements or confidentiality provisions. Confidentiality provisions are another area where these agreements have to be evolving and changing because they've come under serious scrutiny from many regulatory agencies that are charged with enforcing the whistleblower laws, such as the SEC, FINRA, and OSHA. To avoid potentially substantial penalties, employers should include carve-outs allowing employees to report suspected wrongdoing to these agencies. The bottom line is your old forms probably don't cover any of these issues adequately, so don't rely on them.
Thanks, Barbara. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.